that period, there were many events and documents of the United Nations that focused on the importance of development, like the General Assembly's resolution of 1957 for the balanced and integrated economic social progress, International Conference on Human Rights, which held in 1968 in Tehran, which has expressed its belief that the enjoyment of economic and social rights is inherently linked with any meaningful and profound interconnection between the realization of human rights and economic development. The 1969 Declaration on the Social Progress and Development confers all the people the right to live in dignity and freedom and to enjoy the fruits of social progress and should contribute to it. So it is noteworthy that the Africans were behind the development of the idea of the right to development. The idea of right to development was proposed by Senegalese jurist Keba Mbaye with particular reference to the African context. In his speech, he has defined right to development as a prerogative of all human beings and all human beings collectively to have an equal right to enjoyment of the goods and services produced by the community to which they belong. The United Nations Commission on Human Rights recognized the idea of right to development as the human right uh, for the first time in its resolution number 4 triple X triple I of 1947, 1977, sorry. And again, the Commission on Human Rights in its resolution number 5 triple X V of 1979 reiterated the recognition of the right to development as a human right and added the right to development is a human right and that equality of opportunity for development is a as much as prerogative of nations of individual within the nations. Finally, the General Assembly has became able to formally adopt the Universal Declaration on Right to Development on 4th of December 1986 through its resolution number 41 by 128. So the basic component of the right to development under this declaration are the pupil-centered development, the universality of human rights, participation, equity, non-discrimination, respect for all human rights, self-determination. Coming to the controversial aspect of the right to development, this paper examines three main arguments on which this remain under the some controversies. And I will not go into the detail of these points. I will just point out these three aspects. First one is the question of whether it is collective right or individual right. Second one is the controversial right holder and duty bearer relationship. And the third one is the legal status and implementation monitoring mechanism. So now in the conclusion of this paper as well as this presentation, this study provides that though the right to development remained a controversial issue due to the global politics of North and South, the idea is vital for the equitable development of third world countries. It is an integral part of the right to self-determination mentioned under the both of the covenants of the human rights. The right-based approach of the development has inspired the whole idea of Millennium Development Goals, known as the MDGs, and further the Sustainable Development Goals that are the SDGs. It is acknowledged in this study that the right to development is insufficiently being recognized by the country due to the socio-economic, political, and ideological difference around the world. So my presentation come to end here, and thank you all of you.
Thank you, Faisal Mahmood. And now our third participant is Dimple Jodha, research scholar. And
Ma'am,
her topic
Neeti
of
ma'am,
session is, yes, sir?
ma'am, I think Poonam ma'am, she has again joined. Just give her 1 minute and let her conclude.
Okay, Poonam ma'am, you can continue. Please. Poonam ma'am, please respond.
I think she is not there. Okay, next participant.
Yeah, she's not responding. Yeah, third is Dimple Jodha, research scholar, and her topic is a parallel pandemic violence against women during COVID 19. and she's from DNLU Jabalpur. Dimple Jodha. It seems she is not present. So next paper presenter is Preeti Chaudhary, research scholar, and Pratibha Chaudhary. She is also a research scholar, and her topic is human rights and rights of a person with disability in India. And she is from Preeti is from DDU Gorakhpur University, and Pratibha Chaudhary is from Dr. Bhim Rao Ambedkar University, Agra.
I think she's also
Zama sir,
absent.
can you please check are they present?
Yeah, I think she's absent. So
Okay.
our next participant is Mohammad Salim. He's associate professor at Presidency University, Bangalore, and his topic is right to clean and wholesome environment, issues and challenges. Mohammad Salim.
He's from Bangalore.
Yeah, Presidency University. Please unmute your mic. Unmute your
Yeah.
mic. Salim sir.
Yes, sir. Yes. Very good afternoon, all the respected chairperson of the technical session, organizer of the national seminar, St. Thomas School of Law. I, Dr. Muhammad Salim, associate professor, School of Law, Presidency University. My paper of the title is the wholesome right to life and wholesomeness of the environment. These are the basic right which has been guaranteed to a human, the right to clean and the wholesome environment. As discussing on the point of the right to environment and right to life, these are the two important parts of the right to human life. The Indian Constitution guarantee under the right to life under Article 21 of the Constitution of India that no person shall be deprived of right to life or and his liberty without a established procedure of by law. It means, dear student, that every person is independent. We are independent, and our right to life is the most important. But the basic necessities and amenities which are the gift of the natures, these are the creations of the nature. It is a very important, and that is the topic which I have highlighted, the without these bare necessities, which is a clean air, clean water, or an environment, that a human life can be sustained. These are the questions which has been highlighted by this paper and presentation. Hello, am I audible?
Yes, yes, you are audible. You may carry on.
Hello.
Hello.
Yes, sir, you are audible. Continue.
Okay. So that the right to life, including the right to wholesome of the environment, has been the very important discussion as
Hello, sir. Am I
the
audible?
yes.
Hello, sir. Am I audible?
Uh, if you will see in the first declaration of the United Nations
Hello.
Declaration of the Human and Environment, which was held in 1972 at the Stockholm Declaration, which is the very popularly known as the Environmental Declaration for the Sustainability of the Life and the Environment. These are the important questions which has
Am
been
I audible, sir?
discussed.
Preeti, hold on.
Hello.
Presentation is going on. When your turn will come, your name will be announced. Salim sir, carry on. Na?
Okay. Thank you. The environmental problem and the challenges are the common in our society as due to the various exploitations of the natural resources. The Challenges are the mega project has been continuing in the sensitive zones, which I have highlighted in the recently the Tiri. If you will see in the Josimat areas, which is the shrinking, this is the very disastrous to the human existence and the life and the making the balance between the environment and the human life. Yet the persons has been compelled due to these mega project activities to rehabilitate and they are under the threat to the right to life and their survival. These are the important questions that the science and technology, there is a continuous expansion of the industries which has accelerated the environmental degradation and resulted into environmental problems. The degradation of the natural resources has been the important threat to the human existence also. The main reason of the environmental pollution and are the very common, just like as we state is in the part of the urbanization, industrialization, overpopulation. These are the major factors which are responsible for the environmental degradation. But the question here arises how we can maintain the wholesomeness of the environment. Is there relationship which is existing between the air, water, and soil, which is should be realized into a harmonious relationship, so that every person is equipped with all these basic amenities. But it has been seen continuously that with the expansion of these urbanization and industrialization, the pollutant which has been spreading throughout the airs, they are polluting to the environment, specifically the airs and the water. These are the basic amenities. But the question remains with us that right to life under the constitution has been the continuous subject matter of the discussion, that what is the right to life and the dignity of the life. The Indian constitution gives us the basic rights, right to survival and right to settle each and every place as they desire and to carry out the certain activities which are not hazardous. These are the basic parameter which has been mentioned. But we can say specifically the Indian constitutions also mention the basic principle which provide the protections of the environment. Just like the Article 48 of the Indian Constitution mandate that it is the duty of the state as a constitutional obligation to protect and improve the quality of the environment and safeguard the forest and the wildlife in the country. This responsibility has been incorporated for maintaining the relationship of the human and the environment for their survival. The right to life is a dignified life. These are the basic needs as the Honorable Supreme Court in their various judgment has observed that right to fresh air and clean water are the fundamental right. In case of the state of Subhas Kumar versus the state of Bihar, it has been observed very well. And in case of the Andhra Pradesh Pollution Control Board versus MV Naidu, that right to fresh and drinking water are the basic right of the each and every individual, and it is the duty of the authorities to maintain the clean water for everyone. So the question remains with us, the right to life as a human right and the right to healthy environment include the prevention of the environmental degradation? Yes. The My Paper has suggested the various provisions of the Environmental Protection Act 1986, which very easily define a relationship of the air, water, soil, microorganisms, and other uh, substance for maintaining the healthy environment. But on that part, if we see the role of the authorities, which are the pollution controlling authorities, Central Pollution Control Board, State Pollution Control Board, they are doing and carrying their responsibility and liabilities for maintaining the quality of the environment, including the air and water. These are the very important needs of the modern time. That right to fresh air and the clean water has been the subject matter of the cost under the right to life. The Article 47, if we state that the state is bound to eliminate the living standard of the citizen by means of boosting public health and nutrition. These are the very provision under the Indian Constitution as a directive principle of the state policies, which has been, it is the duty of the state to implement these directive principle of the state policies for the better life of the human. If we state on the point of the Article 15.1a and G, that every citizen is obliged to protect and preserve the environment, it has been clearly stated that it shall be the duty of every citizen of India to protect and improve the natural environment, including the forest, lake, rivers, and wildlife, and to have a compassion for the living creature. It means that the Constitution has made the certain obligation not only the individual but to the state also, that we have to be very careful in analysis and protecting the quality of the environment. But the role of the government is very important. Is the judicial analysis I have stated in the year 90, 99, and in case of the Subhash Kumar versus State of Bihar, Andhra Pradesh Pollution Control Board versus M.V. Naidu, it is become very clear that the transgression of any matter in the life of the human being the violate the basic rule of the life, and it is the duty of the state to provide the facilities to the human life and ensure the dignity of the life mentioned under the Constitution. There has been the various development where the Supreme Court has propounded the principles for ensuring the environment, just like the precautionary principles has been the important principle which the Honorable Supreme Court incorporated, the absolute liability principle which has been incorporated by the judiciary for the protection and care of the environment. So it
Sorry for
is
interruption. Salim sir, please conclude
okay, sir. So it
because
is the
maximum five minutes are given to each
okay,
participant.
okay, sir, thank you. So it is the duty of the authorities and it is the obligations of the individual person that we have to be very sensitive and make the awareness relating to the protection and care of the environment, and we have to maintain the equilibrium which is needed for the survival of the human on this planet. Thanking you.
Thank you, sir. All the participants are requested to stick to their timing because everybody has to present the paper. So, our next participant is Jamuna AS, and she will be speaking on the topic Perspectives on Human Rights, a Critical Study. And she is a student of St. Thomas College of Law, Greater Noida, from our college.
Yes, a very good afternoon. Very good afternoon to all my faculty members who are present here, the chairperson and my dear colleagues who are presenting the paper today. I'm making a modest attempt to present this paper as I'm a student. I've done my best and I'll try to put my best foot forward without wasting much time. I would like to say that I'm going to see through the same paper which was presented earlier by another professor, but I would be talking about certain things. I'll be laying emphasis on certain things. So to begin with, yes, of course, my paper is Perspectives on Human Rights and Environment. So there is a connect after the Second World War between the two topics. That is, after the Second World War, that is 1939 to 45, the concept of human rights emerged. And the right to healthy environment as a human right was not the main concern. It became a main concern only after 1972 Stockholm Declaration. And of course, followed by Earth Summit in 1992, which declared that human beings have a right to a healthy and productive life in harmony with nature. Having said that, we all are aware that the Universal Declaration of Human Rights Commission had unanimously voted for a clean and healthy and sustainable environment as a universal human right. So, where is the connect? Definitely there is a connect between the two. It is complementing each other, that is the environmental law and human rights. And the same both human rights and environment have the same goal to recognize the rights of the human and to protect the welfare or the well-being of the humanity. So this interconnect is what has led to the aspect of my presenting this paper. I would like to throw emphasis on Article 21, as we are all aware that it is right to life and personal liberty. But here the added feature here is it is right to wholesome environment. So here, as the fundamental rights when was interpreted, the court had widened the scope of this right to life, and that's how we have seen this as right to life and wholesome environment. Unless and until we breathe fresh air, we don't, like we are under constant threat each time, every time. So environment law, as we are aware that it happened after Bhopal gas tragedy, the whole idea of connecting the air, water, and the land. So we see that the pollutants are there affecting us at every step. So I'm just going to take you through for a few things which I would like to highlight, because already the paper has been spoken. The topic has been spoken by multiple participants. So the doctrines is what I wish to throw light on. So as we have seen that the government has undoubtedly done their best, both in the constitutional provisions, that is internationally Article 253 of the Constitution of India indicates how the procedure, how the decisions are made in international convention, the Stockholm Convention 1972 and so on. So here how they have incorporated this by the parliament legislation, so which is noteworthy and appreciable. At the same time, we have seen that, when the pollution, when the wholesome environment is talked about, we have to ensure that the doctrines are done and it is definitely brought to the notice of the concerned authority. That is, the doctrines which I wish to highlight is polluter pays principle and precautionary principle. So I'm just jumping a few slides in my PPT, which I'm unable to connect to you people. So when I talk about this doctrine, polluter pays principle, I would like to quickly take you through the Bhopal gas tragedy, which became from strict liability, it became an absolute liability after the aftermath of Bhopal gas tragedy. And now this became an absolute liability. So polluter has to definitely pay the principal. And also MC Mehta versus Union of India, wherein, like there are so many petitions was filed under Article 32, which has been the topic was been as to how we are taking care of the humanity or the masses in general, and that is what he was a crusader against pollutions, which we are again, we have the able judges and faculty members who are well aware of this. So to quote a few cases very quickly, just Enviro legal action versus Union of India, that was one, and to take it forward, like we have precautionary principle. I'm moving in quickly. So as a precautionary principle, like we have this Vellore Citizens Welfare Forum versus Union of India. So here, like of course, the Supreme Court stated that how the tanneries and other industries in the state of Tamil Nadu has been polluting it with this untreated effluents, which again is a cause of concern. So as we are all aware, and I want to just reiterate very quickly, so many treaties internationally, Stockholm Declaration 1972, Rio Declaration 1992, and of course we are all heading towards the sustainable development. At what cost are we doing the development? Are we doing the right thing? What is going to be for the future? Is the sustainable development taken care of? And the goals, are we going to meet it eventually, is what my concern was in this paper. So, of course, I have to also state of one last this thing. Of course, Subhash Kumar was a state of Bihar has already dealt with, so I don't want to talk about that right now. I just want to say that the role of judiciary is definitely there. I don't deny the fact, but to what extent? What extent are the people working on this? In the recent case, if I would like to state, we have this environmental issue, that is Central Vista project, or the Rajiv Suri versus GDA case. So again, like we saw a dissenting judgment by Justice Sanjeev Khanna, but so many development projects, so many things are happening. Of course, developing, our country is a developing country, but are we heading towards what? I mean, are we heading towards what we don't want to? Are we going to give something to the future? Are we going to give the something as a sustainable development for the future generation? Is a question to ponder over. So I just, wish to conclude my presentation by saying that in spite of having so many articles to protect right to life and wholesale environment as Article 21 of our Indian Constitution states. Plus, of course, you know how the Environmental Protection Act 246, Article 246, 253, and of course 48A, 51A, G, that is our duty as a fundamental duty of our citizens. Are we going to do that in spite of the directive principle state policy saying in 48A? Are we doing our bit as citizens is a question to ponder over. Also, I mean, that's where I would look to conclude with the questions to ponder over. Are we taking the right steps to stop polluting? What is the accountability we are holding for the industries, manufacturing plants, and so on? Polluter pays principle. Are they actually paying the principle? Unless and until it's a large matter or larger masses, human beings, aquatic animals, if they are affected, then something comes up and they pay, the price. Okay, but the small timers, aren't we doing it? Aren't we, injuring the environment? And of course, the how can we afford, account for this, and who's polluting more? Where is the solution? Where is the country leading us to? So on this note, I wish to give a food for thought for all of us and end the paper. So I hope I've done my bit. I hope I have not let my professors down by this presentation. So yes, any questions for me, Gaudial sir, Neeti ma'am?
Thank you, Zamna ma'am. Thank you so much. You spoke well.
Thank you, sir. Thank you.
And the next participant is Ravi Shekhar, and his topic is evolution of human rights, and he is also from St. Thomas College of Law. Ravi Shekhar, are you there?
इसमें पीछे और था लास्ट
I
वाला
think he's not there.
बनाया था सर हमने जो बनाया था सबको लिया जो था ना वो जो हम लिख कर दे रहे थे
Okay, we'll move on to next participant.
उस पे वो डाला था लोगो और वो अरे वो डाले थे
Next participant is Neetuja Singh. She is assistant professor at School of Law, Sharda University, Greater Noida, and her title of research paper is Advocacy for Menstrual Leave, Basic Human Right of Women.
Hello. Maybe Dr. Ravi has joined the meeting. So, can we proceed for Ravi Shekhar? Namaskar.
Hello.
As Dr. Niti.
Yeah, Ravi, start. Please proceed with your paper.
Yes. Good afternoon to everyone. I am Ravi Segar Singh, a student at St. Thomas College of Law, and my topic is the evolution of the human right. Human right are the right. It's inherent to
Please
the all the.
open your video. Please switch on your video.
Sir, technical issue. My app was not
Okay,
working
okay,
very
okay.
well.
Okay,
खोली
proceed,
तो जो
proceed.
पहले वाला है वो ओपन कीजिए
The human right are the right. It's inherent to the all human being, regardless to our nationality, residence, sex, gender, and the
ये वाला
identity,
था
national
जिसमें
of the
बनाते थे
ethnic
सारे
and ethnic origin, color, regional, and the language, and any
इसमें
other
जो हम चेंज कर रहे थे ना
status. We
बनाया
all
अब
are the
गलत करेंगे
we
तो
all
बाद में
are
फिर
the
आना
equally
पड़ेगा ये
entitled to our human rights without any discrimination. These rights are involved
इस पर
with
वो
the passage of the time to time
लोगो
and
तो
define
लिखा हुआ जो
themselves
डालना
as the
केवल लेकिन
global right. And it's also this right are also given by the virtue at the human
तो
beings,
मैंने कहा था
and
इसको हम
it's
पीछे वाला
also
पेज
a
कर देंगे
natural
जब
right. If we talk
फ्रेंड्स
about the
नेक्स्ट
evolution
में
of the
बैठे
human
उसमें
right, the human right
फिर
concept
बैठ
was introduced in the 20th century, and the most of the various jurists and the most of the philosophers, it can done the various work and a lot of work to develop the human right in the society and the international level. But it's a various certain debate of what the origin of the human right. In the
ये
India, the
वाला जो
human
है
right
काउंसलिंग
comes from
एडिक्शन
the
ये वाला
ancient time. At that time, the Indian
इसको
society
पीछे
have the
कर
human
दीजिए
right.
जैसे ये फाउंड हो गया
In Indian society, there have the three time period. There have the certain development of the human right. The first period is the ancient human right, ancient period, the development of the human right, and the second is the medieval period development of the human right, and the third is the modern development of the human right. In ancient evolution development of the human right, the concept of the human right is the coming from the ancient Indian culture. If you look the word dharma, it doesn't means the definition of religion, if any, in the Hindi term. It means how to live your life. The epic Ramayana and the Mahabharata make us learn that the rule and the regulation of the world. Ramayana define what kind of work done by the king and for their people welfare, and how the kingdom works. The Bhagavad Gita define the Upanishads to the dharma foundation of the whole the universe. The Vedas and the Smriti are the define the concept of the Vasudeva Kutumbakam. The whole world is one, and the whole world is one family. All the Vedas are the insisting the human equality, dignity, and the human beings. During to the 5th and the 6th century, the Gautam Buddha teaching the work effectively to the protected of the human right. At the time, the great king Asoka, it's also the created the various subject and the various policy to the development of the human right and the right of the human liberty and the freedoms. Hence, it's very much clear the ancient India is also the various right of the human, various right of the development of the human right. In the medieval evolution of the human right, in the medieval period, there are so many reform the religious movement, like Islamic religious, it's known as the Sufi, and the Bhakti reformer, it's called the Hindus reformers. Saint Namdev, in the 1270 to 350 CE, he was the promoting the right of the equality, and his philosophy to the people in the society are the equal, and he believed in the equality. And the Saint Kabir teaching to the teaching and containing the dohas and the couplets, he said to the all the religion are the same, all the people are the same, not discrimination between the any type of religion basis. The Guru Nanak, his entire life was the preaching for the universal brotherhood. And then the come of the medieval era, the great emperor of the Mughal emperor Akbar, he was also the introduced the policy Dil Ilahi. He tried to spread the concept of the secularism and the religious tolerance in the society. In the modern evolution of the human rights, in at that time period, the pre-modern era in the British rule, at that time there was the no development of the human right in the Indian society. Only discrimination based on the race, caste, color, place of birth, nationality, and the slavery ruled the economically. Ruined India economically, politically, culturally, and spiritually. If we talk the development of the human right in the international level, then it's come from the Magna Carta in the 1250. The King John declared the first written document. It was known as the Magna Carta. The first charter was introduced by the King John of the England in the 1835. And there are the certain various development of the human right. It's originated from the Western nations, and how he developed all these human right in the various term. And then we come to the petition of the right in the 1628, the petition of right sent by the English Parliament to King Charles, completing of the series of the branch of the law. And he also recognized the fourth principle: no taxation without any concept of the Parliament, and with the and no and the provided the various law, and provided the various human right basis, and the development the human right. Declaration of the right of the man and the citizen of the 1789, set by the France National Constituent Assembly, and he gives the human civil right document from the French Revolution. Then it come from the Bill of Right in 1971. American incorporated the Bill of Right of their constitutional status. The Bill of Right protect the freedom of speech, freedom of religion, freedom of assembly, freedom of petition. And the Bill of Right prohibited the Congress to make any law to depriving the any kind of the person his life and the liberty. And then we come the most affected and the most significant charter was launched in the 1945. It's known as the United Nation. United Nation was the international organization founded in the 1945 after the Second World War by the 51 countries committed to the maintaining international peace and the security, developing friendly relation among the nation, and the promoting social progress, better life, and the living standard of the human right. And then after we can see the various development of the human right, various convention and the various declaration was various
Mr. Ravi
declaration.
Shekhar, kindly conclude. Thank you.
Okay, thank you, sir.
Zama sir,
Okay. Yes, next participant is Dr. Ghulam Yazdani. He is professor at Faculty of Law, Jamia Millia Islamia, and Adnan Irshad. He is assistant professor at Mayanov Rachna University. And the title of research paper is The Role of Judiciary in Expanding the Horizons of Human Rights in Vehicular Homicide Cases.
Adnan sir.
Adnan, sir.
Is Adnan sir is present in the list? If not, then proceed for another participants. Zama sir, kindly check.
इसकी वैसे कॉपी नहीं बनेगी इसमें मैम वो
I
जो
think
हमारे
Adnan sir is not there.
क्रिएट और जो इम्पोर्टेंस के लिए मैंने
Yes, Adnan sir is there.
Neetu Ja, Neet.
No, no, no. Adnan sir is there. So kindly wait and Adnan sir, kindly unmute yourself. Yes. Thank
Good
you.
afternoon, Professor Godial. Good afternoon.
मुझे लगा ना
Yeah, I
शाइनी
just need a
वर्ड्स
second.
इतना
I just
वाइट
need a
है कि
second.
ज़्यादा बेटर कलर निकल आएगा नहीं तो फिर आपने कहीं और भी
Okay, first of all, a very good afternoon to all my colleagues and special mention to Dr. Professor K.S. Bhatti, my mentor at St. Thomas's College of Law. And I feel very happy again to be among my colleagues. A very greeting to Professor Sinha, Professor Fahim Khan, Professor Shalin Prasad Godial Sahab, and of course my colleague Professor Mohammad Zama.
मैम
Uh,
सेशन इसलिए नहीं था कि अच्छा
some of my colleagues are missing. I think Professor Simi is missing. She
Adnan,
might
sir,
be busy
please
in some
start with your
topic.
paper
So my yeah.
and stick to the time.
So the topic of my presentation is, I would be very brief. I mean, I will complete within 3 minutes. Just a second. Yeah. So the topic is the role of the courts in protecting human rights in India, and how the court has increased this ambit. So this is the topic of my discussion, and I have taken a very, I mean, specialized view. I have to deal with the issues of road accident cases. Like for example, if any road accident happens and if somebody dies, so what are the class biases? Like many times we are seeing that people who are dying are basically downtrodden people. So they are dying, and the people through whom accidents are happening, they are basically people who are of the higher classes, or those who can own this killing machine, that is the car. So now in the modern world, it is not terrorism, it is not COVID, it is the roads which are being a place where people are dying and they are being a killing machine. So my topic is this. So I would throw some light on different judgments, how the Supreme Court and High Court have come to the protection of the common people of India. But again,
बनेगा बीच में विवेक सर
I
उसमें
saw that
हाइफन
it
हट
was
गया
very
बीच से
good, very good language was written, very beautiful language was written. But in the end of the day, the sentencing policy and the compensatory relief which is being given to the road accident victims is very less.
इसका लॉ वाला निकालिएगा लॉ का
And I am really ashamed of this. I would like to mention two very BMW case, the famous case of people, and 6 of them were the policemen involved, and the punishment meted out to him was only 3 years,
कंज्यूमर प्रोटेक्शन
and that also 1 year community service was there,
स्पेलिंग गलत है AID
and very less amount of compensation was given. And then same thing in Pereira. There also he mowed down about 8 people, and all of them lost their lives. And then the main controversy is that like if these things happen,
ठीक है
so when then the policeman is supposed to do, that is culpable homicide not amounting to murder. So the law is still not clear. The courts are not wanting to take the onus upon themselves, and very rightly so they are doing this. They are always asking the government to reform the law. So the law should be reformed so that we can impute knowledge if anybody is driving car negligently and in return killing people. So we need a change in law. And here I would quote the example of
देखो और
Bangladesh.
लास्ट वाली
Like Bangladesh also have the same penal code because of course it was a part of India earlier and Lord Macaulay created it. So
इसमें
they
बहुत
have
जल्द दिख रहा है
inserted an amendment under section 304A of the Bangladesh Penal Code. There it clearly and equivocally states that if a person is drunk or even if
तो
he
फिर
is not
सेम
drunk
चीज़ बार
and if
बार
he is
नहीं होती
driving a
है
car at a very high speed and if somebody dies, then they are straight away going to impute knowledge upon
अच्छा
him
हाँ वो
so that he can be straight away booked under
एस
section
लगाना है
304
एकदम
part
जो
2,
आपने अंदर किया
that
था
is
फिर ये
culpable homicide not amounting
हाँ
to
हाँ
murder.
ये एस हो गया यहाँ पर
So this can bring some
और
relief to the
ये वाला हो
citizens.
गया
But
रेड
in
वाला
India, it is
हाँ
very
ये वाले
unclear.
कर
We
देना
have seen the
ये तो है ही क्योंकि
case of
इसमें
Salman
सेम चीज़
Khan.
है ना
It is very
सर
doubtful and
यहाँ
very
पर
deceitful.
हाँ कर दिया
And
मैंने
now again, Deepak Mishra, Justice Deepak Mishra has written a very good and a very flowery judgment in 2015 in the famous case of Saurabh Bakshi versus State of Punjab, where two
हाँ
people were killed in a
करा
road
दिया
accident. But finally, he also meted out the punishment of 24 days,
ये फर्स्ट पेज
which
वाला
the
ये
accused has already undergone. So
इसमें
this is the
सेशन भी
state of
लिखा है
affairs. So I think the judiciary should come up to the mark and it should also work, and it should force the government that they should frame certain policies or regulation,
सर
or
दूसरा
otherwise
प्रोग्राम में
the
लिखेंगे
constitution has always given power to the apex
हाँ
code under
सेम
article
लिखना है यहाँ से
141 to
यहाँ
frame the
से
laws
और
for the
ये यहाँ तक
protection
आना
of the
चाहिए
vulnerable sections of the society. So this is my analytical research with reference to the cases which are happening in human right violation and class violation of human rights of poor people and destitute people in India. So this is my take, and here I would like to conclude my speech. And thank you everyone. Thank you so much.
ये सब यही है जो स्टूडेंट्स को ये दे रहे हैं सिर्फ
Thank you
लर्नर्स
so
तक
much.
करो मैं सब छोड़ दूँ ये करना
Thank you, Mr. Adnan sir.
सर सेशन
I
कब
request
होगा
our judges to give any remark. If they have any remark, they can give.
ये इस तरीके से जैसे ये वाइट ऐसे वाले पे होगा ना तो फिर ये नीचे इतना ये ऐसे वाइट रहेगा रेड्स ये कलर्ड आ जाएगा ये फिर अंदर को दिखेगा
Zama,
पीछे वाला पेज
it
भी
on what or is still?
No, sir.
I
No.
simply want to welcome Professor Adnan, and
No, Puneet.
definitely we have always held you in very good esteem. So it's a pleasure to see you on the conference. All the best.
तो बाकी वही रहने तो प्रिंट आउट सिर्फ
Sir,
इतना ही
you
चेंज
have
कर देना
always been my mentor, sir, and really
हाँ
happy
बाकी
to
सारे
see you.
पेजेस
Thank
को
you so
लिखना
much, sir. It is a very successful
ऐसे
conference going on. I am really very happy for the entire team, sir, and I am very, I
Thank
mean,
you, Adnan sir.
happy to
Next,
और
be
जैसे
a
next.
part
इसमें
of it.
हुआ ना ये एक पेज लगा दूंगी
Thank you. Really, it was good presentation. Next participant is Dr. Neetuja Singh. She is assistant professor at School of Law, Sharda University, and the title of her research paper is Advocacy for Menstrual Leave, Basic Human Right of Women. Dr. Neetuja Singh.
I think she has not
I think she is absent.
she has not joined yet. So proceed for next participants.
Next participant is Khan Nazma Sorab. She is a research scholar at Gujarat National Law University,
Zama
Gandhinagar, and the title.
call Preeti Chaudhary. She's waiting for a long time. Ne?
Oh, sorry, Preeti Chaudhary. She has left.
Sir,
Are you there, Preeti Chaudhary?
sir? Yes, sir. Am I audible, sir?
Yeah, you are audible. You can continue with your paper. Preeti Chaudhary, her title of her research article is Human Rights and Right of Person with Disability in India. Preeti Chaudhary, she is a research scholar at DDU Gorakhpur.
Yes, sir. My name is Preeti Chaudhary and I am a research scholar from Deen Dayal Upadhyay, Gorakhpur University. First of all, a very good afternoon to all present here. Um, my presentation paper title is Human Rights and Rights of Person with Disability in India. First of all, I would say that all the human rights and all the fundamental rights and specific statutory rights, those all are available for the person with disability. The basic reason is that they are the human being, they are the persons, they are the citizen of India. So whatever rights are available to a person, to a citizen, those rights are also available for a person with disability. and their United Nation convention which are dealing with the specific matters, and they are also having the provision for health besides the specific convention, that is Convention on the Rights of Disability 2006, the Rights of Disability Act 2016 in India, and other countries also have the laws to protect the rights of person with disability. We see that the international level and national level and globally there are statutory provision, there are human rights, and there are constitutional provision which speaks about the rights of the person with disability, like rights of freedom of expression, and right to work, uh, uh, prohibition of the discrimination, etc. So first of all, it's a very important to know what is disability. And the first important convention that come to the mind is the Convention on the Rights of Person with Disability, also known as CRPD. CRPD 2006. It is adopted by the United General Assembly 13 December 2006, and enforcement date is 3 May 2008. India has also ratified this convention on 1 October 2007. This convention is helped to recognize the person with disability. But in this convention, there is not any definition given by the United Nations. So, defining disability is the most difficult task. This is a very inclusive. That CRPD Article 1 provides that the person with disability includes those who have long-term physical, mental, intellectual, and sensory impairment. Those persons are called as a person with disabled. And RPD, Rights of Person with Disability 2016 in India, right, Section 2, Clause S also provide the same things. The person with the long term physical, mental, intellectual impairment, that's why the disabled person is not actually participated in the society like normal people participated in the society. And disability is a unfortunate part of the human life, which can affect not only the natural ways of a living but also despair components, strength and power. So we can human rights are not just to stand up with respect to the society. Human rights are not just rights but self-respect for any person. Therefore, a person with disability is a special person who needs to a special attention. So he should be give special human right to conclude by the ratifying the UNCRPD in 2007. Thank you, sir.
Nazma Khan,
Next
please ready.
participant is Nazma Khan.
Good afternoon, everyone. Am I audible?
Yes, you are audible.
Good afternoon, everyone. Thank you so much, St. Thomas College, for giving me an opportunity to present my paper. The title of my paper is Data Privacy and Security Issues in Cyberspace with reference to the role of intermediaries. Why this topic? The reason is simple, as the violation of privacy, compromising of data, and surveillance. These are the topics which are continuously in news. With the advancement of technology and access to the internet, we are at the verge of security risk. How our data is being protected? When we access these platforms, online platforms, just with a single click, we can get numerous information, the information about anything we want. But when we use these, when we access these internet, what security, what protection do we have? There is, when we say that we are at the security risk, then we say that our data is being at the risk of its protection. Data can be breached through various means. How that can be breached? Through malware attacks, phishing, and sharing with the third party. As we can say that these malware attacks and phishings take place more with the just with links, emails, with the sent of emails. I would like to highlight one example, that Yahoo employee who was having the access to the database have received the link, and unfortunately that employee clicks over that link, and 300 billion accounts have been hacked. So this large data breach, we can say. On the other hand, when we say that the sharing of the data with a third party, now this is where we can see this with the example of WhatsApp privacy policy, the WhatsApp privacy case. Whereas the privacy policy of WhatsApp, we this is the instant messaging application where we use it everyday basis. I don't know how many of us have gone through the details of this privacy policy, whereas it speaks about the collection of the data, the storage of the data, and everything, and sharing the information with the parent company, that is Facebook. Our data is being shared with the parent company, Facebook, without even our consent. And what consent, that we just click over the policy, that we accept it without even going through into detail of the policy. Now this case is being taken by the legal practitioner, that Karmanya Singh Sarin and another versus Union of India. This is ongoing case, whereas the Delhi High Court have declared that you have to stop it, advise the WhatsApp to stop its policy from rolling out. And this WhatsApp privacy policy speaks that we collect the information, we store basic informations, but when we read it further, they have played with the words stating that the metadata. Now, this metadata word, they are playing that meta means big. Big means huge amount of data which is collected. Every information is being gathered under this one word, where we are unaware about this because we don't even read the policy. So here there is a risk to our privacy policy, data privacy policy, with these kind of platforms. To govern these platforms, the government have taken the initiatives to make the rules with the passage of time, that the IT Act, we are very well aware about the Information Technology Act 2000. Under that act, government have made various rules. Rule 2011, in 2021 recently, the Information Technology Intermediary Guidelines and Digital Media Ethics Codes, Rule 2021, which speaks about these platforms, which governs these platforms to an extent. It says that it categorizes intermediaries into two: social media intermediaries and the OTTs. The social media intermediaries are the intermediaries which is Facebook, WhatsApp, Instagram, etc. And OTTs are the Amazon Prime, Documents, web series, and Netflixes. All these, to govern them, the rules further categorizes that social media intermediaries and significant social media intermediaries. These social media intermediaries are the intermediaries which are having less than 50 lakh of the users, registered users. I'm sorry. And the significant social media intermediaries are the ones who are having more than 50 lakh registered users with them. Now these intermediaries, they have the roles and responsibilities. What responsibilities they have? To protect the privacy of the users. Now when they what conditions are there for protection of the rights of the users, that they have to follow the due diligence. They have to keep a track that the information which is circulated on their platform is not violative of the national security, is not threatening the security of the nation. And the other is traceability. Traceability means where they are bound to trace the originator of the information, where if the fake news is being spread over the platform, then they are responsible to trace the originator. And the government is having a power to, under these guideline rules, that they are having a power to take legal action against the first originator of that information, the fake information which is being circulated over the platforms. Now the other is removal of the content. Now they are bound to remove the content which is violative, as I said, which is against the national security, which is hampering the security of the nation. And the other is compliance officer. They have to appoint, they are, it is mandatory for them to appoint the officer who can take the cognizance of the complaint within 24 hours of receiving the complaint and resolve it within 15 days of the receiving of the complaint. Now they have roles and responsibilities. On the other hand, they also have the immunity. Now under section 79 of the Information Technology Act, they receives safe harbor. The safe harbor means that immunity from liability. How they are immune from the liability? When they take all, when they fulfill all the conditions, that is due diligence, when they take due diligence and all the protections and securities have been taken. And if the information is circulated, they, if they are not aware about that, that without their intention, without their information, without their modification, if the information is being circulated, then the safe harbor provision is applicable to them. Now to an extent, these provisions, these guidelines, these rules becomes insufficient to tackle with the upcoming crimes in day to day life, because in protection of the rights, privacy rights, data privacy rights of the users. Therefore the government have rolled the data protection law, which was rolled out in 2019. But to have a more stringent and more strong law, the government have brought a new law, that is the Digital India Act, which is rolled out recently. The discussion is on. And how these how things will take place, what, who will be included under these, what
Uh,
intermediaries will take
Azma
place.
ma'am,
One
please.
second.
Yeah.
I'll just find out.
Yeah. Okay.
I'm at the conclusion.
Okay.
Who all will be included under this? This is unanswered question. We have to wait until the Digital India Act comes out and hope for the stronger and stringent law for the protection of data protection of the users. Here I end my presentation. Thank you so much.
Thank you, Nagma. The next presenter is Sabir
Thank
Kausa.
you
She
so
is
much.
a research scholar at Department of Law, University of Kashmir, and her research title of her research paper is Rights of Tribal Women in India: National and International Standards.
Yes, this is Sabil Kausa, and I'm a research scholar at Department of Law, University of Kashmir. The title of my paper is Rights of Tribal Women in India, National and International Standards. So, should I start?
Yes.
Yes, start.
Okay. So, basically, if we see women in general, they're subjected to various forms of atrocities, and particularly the tribal women. There's an added stigma attached to the tribal women for being indigenous. They are disproportionately experiencing systematic discrimination and injustice. And one important point is that they majorly belong to the low income strata of the society. Besides that, they face lesser access to the healthcare, education, and they have lesser access to the means of different means of livelihood. Their plight is further aggravated by the massive displacements that results in food insecurity, poverty, violence, domestic abuse. Undoubtedly, steps have been taken at the national as well as international level to address this concern. We talk about India. In India, various articles, various constitutional provisions in the form of fundamental rights or directive principles of state policy or other provisions are there to protect the rights of tribal women. In fact, legislations in the form of prohibition of employment as manual scavengers and the Rehabilitation Act 2013, Prevention of Atrocities Act, these acts are there. So, but what is the implementation of these acts that needs to be seen? And there are more other acts. At the international level, also, India has ratified many conventions and implemented various measures and commitments specific to women, and which indirectly applies to the tribal women as well. So, naming one important major convention, that is the Convention of the Elimination of All Forms of Discrimination Against Women. that is in 1994. India has ratified this international convention. So, my present paper endeavors to analyze India's success in its national and international commitments. So, to start with, if we see the tribal population, India has 8.6% of the total tribal population of India, which is a major number. If we see that as I've started my at the very inception of my paper, I've started by saying that women generally are belong to the marginalized section of the society, and not to speak of the tribal women who are in fact more marginalized than the already marginalized section of the society. In India, if we see the female literacy rate, it's very less as compared to the okay, times are changing, there has been a shift, but as compared to the male literacy rate, it's comparably less. And the tribal women literacy rate is far more less than the national female literacy rate. So this is just one example to cite that still a lot needs to be done in this area. Talking about fundamental rights, if I point out the legislation, which is my main topic, that what are the national and international standards in India. So starting with part third of the constitution, that is the fundamental rights, we have the equality code. As we are all aware, we have the article 14 that is generally talks about the equality. So everybody, that it clearly states that equality before law and equal protection of laws. And here we need to know that equality means that not that all needs to be treated equally. It's like likes are to be treated alike, and there needs to be a reasonable classification which need not be arbitrary while we are making this classification. So here, Article 14, we have the ambit of Article 14, Article 15, which specifically provides discrimination on the basis of race, caste, sex, or place of birth. Under Article 15.4, we have the special arrangements can be made for the socially and educationally backward classes of citizens. We have Article 15, Clause 3, which talks about the positive discrimination in favor of women and children. So, Article 16 ensures equality of opportunity in matters of public employment. So, I'm indirectly linking it to women and then to tribal women. So, I'm just saying that laws are there to start with fundamental rights. And then by virtue of our 77th Amendment Act, wherein Article 16.4a was inserted in the Constitution, positive steps have been taken to enable the scheduled tribes to have an equal
Uh,
opportunity in matters of public
Sabir,
employment.
ma'am, can you please conclude? Thank you.
Okay, so in my paper, I have tried to point out the directive principles as well, other constitutional provisions which include Article 15.1a and international safeguards, as I was pointing at the very inception, that there is CEDAW convention in which India is a party to, and it has in its various provisions. It does talks about the rights of women and tribal women in short. So in India we see a lot has been done. These constitutional provisions ensure that the women in general, including the tribal women, are given adequate protection vis-a-vis their rights. It also ensures that they duly represented and their grievances are addressed to. But given the present scenario, despite the safeguards in the form of constitutional provisions, legislative enactments, schemes, and other welfare measures, a lot needs to be done to address this section of our society. Women of
So,
tribal communities
thank you,
face
ma'am. Thank
tremendous.
you. We have to.
Okay, thank you for your time.
Thank you so
Thank you
much.
so much. Okay.
So, next
Thank you,
participant is,
Sabir. It was
yes.
really good presentation.
Ramazar, kindly call Dr. Sazia, ma'am. Sazia, ma'am is present. If Sazia ma'am is not there, kindly invite Dr. Nituja Singh.
Gorial sir, just a minute. Oh,
Okay.
I think Pezan sir, he has some meeting, so
Okay.
I request him to give some concluding remarks.
Yeah, sorry, actually, there's some departmental work, so I have to leave there. I would love to be part of this seminar till the end, but I have to leave because of some department and some time issues. No? So simply, I can say that I really enjoyed the afternoon and was amazed at the amount and the quality of work that the presenter had put into their deliberation and the precision of the approach and the presentation. and everyone who took part has much to be proud of. And I must say that I am very impressed by the quality of presentation. I hope for me to choose a winner, and to choose a best three paper. So in the end, I could say that the speaker who displayed the most poise, wit, and the command of fact, in my opinion, uh, if I have to say that you all are the winner. And the simply I could say that for a good presenter, there are certain characteristics which need to be there. That the good presenter should focus on their gesture, and then they must focus on their vocabulary, emphasizes and voice modulation, oratory skill, diction, accent, and posture to increase the effectiveness of the speech to describe the topics. These are the few tips which I would want, which I would want to convey to all the presenter for the future endeavors. And I thanks all the member of the organizing team, and more specifically the principal and the organizing secretary Mohammed Fahim for inviting me to chair the session. Thank you. Thanks to all.
Thank you, Professor. Thank you, and we'll bother you also when the publication
No, no,
comes.
every time,
And
anytime,
your
sir. But
words
I'm
of
sorry that I
wisdom
have to
to
leave in between, but there's some department work that for that I have to leave, sir.
nice,
Sorry
sir.
for for
So
any
nice
for
of you. Thank you very much.
sorry for inconvenience, sir.
We are grateful for your participation and
Thank you, sir.
guidance.
Thank you, sir. Thank you,
Thank
sir.
you.
Thank you, sir. Bhati, sir. Thank you, all professors.
Okay, so next participant is Zubi Ali. He's a student at St. Thomas College of Law, Greater Noida, and the title of her research paper is Demolition of Houses and Right to Shelter. Zubi Ali.
Good afternoon, everyone. My name is Zubi Ali, and my title is Devolution of Houses and Right to Shelter. Right to shelter is one of the most important fundamental rights which has been recognized. It provides protection against the force eviction and demolition of one houses. The right to shelter includes adequate living space, decent surroundings, sufficient light, pure air, water, and other civic amenities. Right to shelter is a fundamental right guaranteed under Article 90E of the Indian Constitution, which states that every citizen has the fundamental has freedom to reside and settle in any part of the India. Fundamental rights are divided into two parts. In the first place, right to reside is in any part of the country, which means to stay at any place temporary or permanently, and in the second space the right to settle in any part of the country has been ensured to every citizen, which means to set up a domicile at any place temporary or permanently is a right of every citizen. This right mainly addresses the barriers which have to be removed within the territory of India or any part of it. Right to shelter also embodied under Article 21 of the Constitution of India, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. The right to life and personal liberty has been interpreted by the apex court in the some of the landmark judgments widely include the right to live, health, education, shelter, environment, and all those matter that contributed to life with dignity. In the landmark judgment of Rajesh Yadav versus State of UP, it was held that right to shelter is a fundamental right and the state has a constitutional duty to provide shelter to the poor. The weaker section of the society, like the poor and agriculture labor, has the basic human right and constitutional right to the resident. Thus, it becomes a duty of state.
Ruby Ali,
Yes, sir.
can we conclude because we have lots of speakers are
Okay,
there.
sir. Okay, okay. Sorry, sir. I will conclude.
Thank you.
Like in most of the landmark judgment, like Sudhama Singh versus State of Other and Delhi and others. And we also have international provisions like in UDHR and CCPR. The Universal Declaration of Human Rights under Declaration adequate housing and shelter recognizes a part of right to an adequate standard of living under Article 25 of the Declaration, which states that every person has the right to understand or live healthy life for himself and for being of his family. And in most of the recent incidents of eviction and displacement, like in areas of Delhi, uh, Jahangirpuri, and in Uttarakhand, Haldwani case, as we all know about Haldwani case, Supreme Court of India has placed a great emphasis on the guarantee of housing right as a part of larger goal of achieving a social and economic, which is also a fundamental constitution objective. Article 125 in the Constitution has stated the protection and promotion of right to shelter to some dwellers in the need of the are in the developing India today. Thank you.
Next participant is Dr. Sazia Parveen. Is Sazia Parveen is present there, ma'am?
Yes, sir, I'm present here.
So,
And the topic for my paper is impact of globalization on human rights. So I would like to say that, considering the time, I will like to be in the limit of the time. So I would like to summarize that, as we all know, globalization is the trend after Second World War, and because of the commercialization and everything, slowly and gradually, globalization is increasing day by day. So, as we all know that human rights, and with the human rights has its a lot of dimensions. It is very much related to the each and every factors which is I mean going through the surrounding. So globalization is also has its a great impact on human rights, and as we all know that globalization means that there is no boundary and the whole world is like a family. So if there is no boundary, then certain rights undoubtedly it is being protected, and certain rights are also not being protected. So firstly, I would like to say how the globalization has benefited the human rights. So as we all know that human rights is like the rights which are essential for the human growth is termed as the human rights. So how the globalization has positively affected, because of the globalization we are very much internet and internet facilities and communication facilities, transportation is very much encouraged. Because of this, we are able to get the desired information, and desired information, as well as we are able to receive the good and commodities from the far away also. I mean, as there is no national boundaries, so we are able to get the goods and information very easily, and very at a very affordable rate. Secondly, how it has benefited, globalization has helped the business also. I mean, but unfortunately the globalization has helped the biggest monopolies and biggest industrialists, because as we all know that whatever there is international phenomenon, it is mainly governed by the WTO, the World Trade Organization, International Monetary Fund, and all these type of institutions, international institutions. And these international institutions are mainly governed, or it is I mean hijacked by the most powerful countries of the world. So these powerful countries are the one who manipulate, who are very much I mean, like, they influence a lot of laws and laws of business also. So as their dominance is in the business or in the rules and regulations of international institutions, so they manipulate the rules and regulations, and it benefits it tries to benefit who are at a greater who are at the good positions, already at a good positions. Simply that means the small farmers, the small entrepreneurs have to fight with the global names, have to fight with the global businessmen. And because of the lack of resources, because of lack of I mean good at cheaper rate, they fail to compete with the big names, or the big business names of the world. Thirdly, as we as my paper, as a research as my I mean, in my research paper I have highlighted different rights. Firstly, I have done with the, I mean, how it has affected the business. Then I have done with the how the economic rights have been violated, that I have discussed right now. Economic rights of the big names is not being violated. They are, I mean, they are growing at a greater speed, but unfortunately, the small businessmen are not able to cope up with the changing world, with the changing big names, and with the changing policies, because the policies are also very much favorable to the big businessmen. If I comes to the social rights, how the social rights of how the human rights has been violated by the globalization. So social is like, because of the globalization, we are able to socialize. It is in a positive sense. We are able to socialize with the entire world through the ICT. I mean, information and technological instruments. We are able to socialize with the whole world. So that is why we are. I mean, now especially the new generation is very much on the soft, on the, I mean, Insta or Facebook and Twitter and I mean these things. But if we see the other facet of it, then we are going to recognize that although we are very much active in the social medias, but we are unaware of the, I mean, unaware of our neighbors also. We are unaware of the societal issues which is going through going in our surroundings. And social impact, okay, social impact is like, as I have just said, that globalization has positive as well as negative impact. Socially we are very much connected, but actually in a physical mode, I mean, we are very much unaware, we are very much immune, and we are least bothered to our neighborhood surroundings. This is really this has really impacted very badly in the social upbringings and in the social awareness. Now next comes to the culture, how the globalization has affected the cultural rights. So if I talk about the cultural rights, then we
Asya
can
ma'am,
see.
can we conclude? Can we conclude?
Okay, sir, I was also not
We
listening.
want to urge
My
you, but is a time
नहीं
limitation
नहीं
here.
I understand Godial sir, I understand. I was also really
Godial
unaware
sir,
that.
Yes.
Godial sir,
Ah,
better
Okay,
give
thank you,
opportunity to few people who are eager to
thank
ask
you.
the
right, ma'am.
question.
Right. Sure, ma'am. Sure.
Okay, so
Thank you.
Sajia ma'am,
Yeah, sure, ma'am. So
Sajia
next,
ma'am.
thank you, ma'am. So
No,
next
no,
हाँ
question.
Godial sir, I have a question from Sajia ma'am.
Acha.
Okay,
okay,
Sajia ma'am.
हाँ जी, I'm listening.
Yeah, ma'am, I think human rights has come through the globalization. Means prior to UNO platform, there was
Discuss.
not domestic at domestic level. The concept of human rights or as such was not there prevailing. So UN
नहीं नहीं, I would like to
ODHR
I would
it
like
has
to.
came into existence. Yeah.
Ma'am, just give me 2 minutes because my department is going to close. Just give me
Okay,
two
okay,
minutes.
please,
Just give me
please.
2 minutes.
Okay, so
भैया
better.
बस
Yeah,
दो
no,
मिनट
no,
बस दो
this
मिनट
was
ठीक
my
है.
question.
हाँ नहीं नहीं, I'm like I would like to answer your question. You just said that human right is a
UDHR,
Western
yeah, through
concept, and
UDHR,
it
not
and it
Western,
came because,
global,
yes
ma'am.
ma'am,
It came
let me
through
answer you.
global. Yeah.
I understand. Let me answer you. First of all, you said that UDHR is a westernized concept. It is because of the globalization. Okay. Undoubtedly, the terminology was given through the UDHR. But the concept of right is not at all new. The concept of right can easily be seen through the doctrines of Akbar in the Manusmritis and in the Vedas, or in the doctrines of Akbar also. I mean that Din Ilahi also reflected. Also, and Buddhism and Jainism, they all are the promoters of human rights.
So
Although
those
they
are
were the promoters of
religious
rights.
tenets.
Listen please. They are the promoters of rights. Okay. They are the promoters of right. And
Can we have question?
your first answer, your first question was UDH. No, human rights is because of the globalization. No, human
No,
rights was
my
earlier. The
question
terminology
was,
was given.
ma'am,
The
my
terminology was
question
given
was
in the UDHR.
human rights has came through global to domestic. The emergence of human rights is not from domestic to global, like economic policies, liberalization and privatization. So earlier the economic policies were conservative. So the impact of globalization over those all things and legal rights. What I am observing, I may be wrong, that your paper is focusing over globalization from the human rights perspective, okay, but you are dealing with the different set of the legal rights. Is it? Economic
Ma'am, the
rights,
paper,
social rights.
ma'am, my paper is about I mean, how the globalization has affected all the variants
Human
of
rights.
human rights.
Yeah, human rights.
So if I talk about the variants of human rights,
Okay.
then human right is not only concerned with two, three aspects. It is, if I broadly categorize, it is concerned about the economic, social, cultural,
Yeah,
environmental right.
different generations of
All
rights.
these things comes,
Yeah,
all
different generations
things
of
comes
human
under the
rights.
human
Yeah.
rights.
Hmm.
And the second is
Uh,
how the globalization,
yes, Dr.
what
Sanjay
happened,
ma'am,
that
Dr.
undoubtedly
Neetuja.
globalization, because of this.
Yes, can I interrupt? Sorry for the interruptions. So we will
Yes, sir,
have
yes, sir, sure,
more
sure,
rounds
sure.
in future, but right now I would like to introduce Dr. Nituja ma'am for to come, and she has a topic advocacy for menstrual leave, basic human rights of women. She's from Shada University, School of Law, Shada University. So thank you, ma'am. Please,
तुम जाओ.
over to you.
Okay, thank you, Koryal sir, for ultimately my turn
I'm
came.
really sorry, the time is not enough.
Should I,
Yes,
Koryal sir?
yes, ma'am. Thank you.
Okay, sir. So, topic as you have mentioned, advocacy for menstrual leave, a basic human rights of women. Menstruation cycle is one of the fundamental and distinguished biological characteristics of women. Studies on women health show that almost every woman faces certain health issue, whether mental or physical, during these menstrual periods. For example, stomach ache, headache, thigh ache, fever, breast pain, vomit impulses, itching, mood swing, irritation, lack of appetites, etc., etc. So many list is so long, sir. And these all symptoms are in addition to constant blood flow for an and of average 3 to 5 days. It may be twice in a month to some women or to every woman during certain period of age or illness. This was one of the post COVID-19 impacts on women health, that they observed some abnormalities in their menstrual cycle or flow. Women have always been claimed in every civilization as wise, intellectual, prudent, active, and well forecaster. Surprisingly, she never claimed or declared any holiday for herself from her family, society, or from the system she has been living as citizen, even during her health crisis like menstrual cycle periods. She did not ask any relaxation. Does not mean she did not feel pain or she did not suffer health crisis. Of course, she does. But as a co-fellow, as a community fellow, we did not ever notice their pain or grief. Even in 21st century, not much has been talked about it. In fact, the blood stains on the cloth of women are still a matter of shame for her and for the next fellow. We hesitate in discussing women menstrual issues in public. We can observe that the name for the sanitary pad to be used during the menstruation period is the name whisper. So we can see the sensitivity, undue sensitivity associated with the society was supposed to make awareness, spread awareness, but society has chosen to make it secret. Though it's already too late, but distance doesn't matter. It is always the first step towards a right decision that matters. Menstrual leave raises a number of questions regarding women's health, workforce participation, and the gender equality at work. Menstrual leave policies, though well intentioned, could have negative consequences for gender equity and need to be deployed with caution. The Indian constitutionalism is based on, inter alia, two core facets of law, that is, equality and justice. The application of the theory of equality has always been more needed for a society like India, where same people were treated unequally on many layers and grounds. Caste is one among them. India is the society that has been proud over its ancient culture with reference to female related matters. We have been hearing since our childhood, yatra nari pujante tatra ramante devata, etc. So they have been claiming that it is we, means Indian culture and Indians have been claiming that it is we who have been worshipping female goddesses, child girls during Navratri, etc. However, they never see a discriminatory and gender evil in the female child girl feeding and worshipping practices during Navratris. Actually, the religious practice among Hindus is to worship and feed girl if they have not attained the age of puberty, meaning thereby if menstruation of a girl child starts, she will not be considered to be worshipped for the purposes of Navratri Kanya Puja. The question is why a girl is stopped to be considered for worshipping after the age of puberty? Does menstrual cycle make a girl lesser girl? What exactly get changed in the quality of girlhood that society starts to look differently the same girl who was being to be worshipped prior to menstruation cycle? Another example is the tradition and practices of Sabrimala temple women entry age related issue, which has now been declared unconstitutional by the Honorable Supreme Court of India. Prima facie, it seems as if the ancient Indian society had associated menstruation, a biological characteristics of women, with matter of sanctity, that is purity, and it continued status quo during the course of time. The different phases of Indian civilization have changed social behavior towards women in many aspects, but not towards menstruation. Menstruation of women sh- should have many layers which really should be discussed in public and oriented towards addressing the socio-eco-legal vis-a-vis health issues implicated.
Please
Yeah, sure,
conclude.
I'm coming to that. Indian society should move on from its primitive outlook wherein menstruation of women has been limited either to a blot on her clothes as a matter of shame or a sign of purity of womanhood. I conclude that now the society, especially the working woman herself, should claim menstrual leave as a matter of human right from legislative body of India. Thank you. I'm done.
Thank you, ma'am. The next participant is Abhijit Chanda, research scholar, and Nisha Ghoshla, LLM student from School of Law, Sharda University. And their topic is
Thank you, sir.
contribution of judiciary in protecting human rights.